The 9 judges of the Supreme Court unanimously upheld President Museveni's election victory. Immediately after the ruling, Mbabazi's lawyers led by Asuman Basalirwa cited the loopholes in the ruling, pointing out the judges rejecting their evidence.
They said on the whole, when they look at those irregularities, when they look at those malpractices, they are not sufficient enough to move them to annul an election.
We think that when it comes to matters like those of the crime preventers, for example, and their involvement in the entire electoral process, we thought the courts should have addressed it better.
DP President Norbert Mao says he had already anticipated the decision.
We think there were enough grounds, and indeed the evidence adduced, however little, was enough to give the court ground to annul the election and declare that Museveni was not validly elected.
The Minister for Presidency, Frank Twinobusingye, says it's incumbent upon the opposition to accept and respect the court's resolution.
President Museveni, as alleged by his adversaries or petitioners, has been cleared of all alleged wrongdoing and electoral offences on him as an individual.
Asuman was on the Electoral Commission's legal team.
They came up with so many allegations, and I think it is only in respect of the late delivery of polling material where the Electoral Commission has been faulted.
However, Asuman Basalirwa, one of the petitioner Amama Mbabazi's lawyers, says new precedents have been set, one of them being the joining of the Friends of Court in the election petition. The Makerere University dons joined the case as amicus curiae, with their role being restricted to interpretation of the laws and proposal on good election practices.
They allowed a presidential petition to be amended. That is unprecedented. It had not occurred before. Number two, they set guidelines on how Friends of Court can be admitted and the role they can play.
Basalirwa has advised the executive to respect the court's concern on constituting meaningful electoral reforms.
That the idea of bringing, legislations late and the idea of bringing legislations that don't impact positively on the electoral process is not good.
The chairperson Foundation for Human Rights Initiative, Dr. Livingstone Sewanyana, says the court's decision was expected given the nature of the evidence adduced.
The petitioner had difficulty in proving that he had evidence to show the contrary. In fact, in one area where the courts really based themselves to make their final judgment, they said that the petitioner did not have independent evidence.
The judges will give the final detailed ruling in 90 days. Herbert Ziwa, NTV.